So I wanted to talk about the legislature's constitutional provisions. Now, most of the provisions pertaining to the California legislature are found in Article 4 of the state constitution, although there are provisions affecting the legislative branch of government in half a dozen other articles of the state constitution. But let's stay focused on Article 4 and go through in summary fashion the different sections. Section 1 vests the legislative powers in the legislature, which is bicameral with an assembly and a senate. And the powers of the initiative and referendum are reserved to the people. Section 1.5 is a findings and declarations section related to having a representative government based upon free and fair elections, but requires term limits, restricted retirement benefits, and limits on resources for legislative staff. Section 2 provides for the Senate with 40 members elected to 4-year terms, and the Assembly with 80 members elected to 2-year terms. Legislators may serve a maximum of 12 years in either house or a combination, and they're elected in November of the even numbered year and must be residents of their district for at least 1 year, a citizen of the United States, and a resident of California for the last 3 years. And the governor calls a special session whenever a vacancy in the legislature occurs. Section 3 specifies the legislature convenes at noon on the first Monday in December of the even numbered year and then adjourns on November 30th, 2 years later. Extraordinary or special sessions are proclaimed by the governor, and legislators can only legislate on the subject of that gubernatorial proclamation. Section 4 of Article 4 prohibits legislators from receiving any salary or earned income from lobbyists or lobbying firms or anyone with a contract with the legislature during the past 12 months. Travel and living expenses are passed by a 2/3 vote of both houses of the legislature, and these expenses may not be received if the legislature is in recess for more than 3 calendar days. Section 4.5 requires legislators elected after November 1990 to participate in federal Social Security, and the state pays for that. No other pension benefit can accrue to a legislator. Section 5 provides that the Senate and the Assembly judge the qualifications and elections of their members and may expel a member with a 2/3 vote. Legislators are prohibited from accepting any honorarium, and the legislature is required to enact strict limits on gifts. Legislators are also prohibited from accepting compensation or taking any official action on behalf of another person before a state agency or board. Legislators may act on their own behalf, and they can advocate without compensation or make inquiries for information on behalf of other individuals before a state agency or board. Legislators are also prohibited from lobbying the legislature for 12 months after leaving office, and the legislature is required to enact laws prohibiting legislators from engaging in activities that conflict with their official duties. Section 6 requires the state to be divided into 40 senatorial and 80 assembly districts, with one of each person selected or elected to represent each of those 120 districts. Section 7 grants authority to each house to choose its officers and its rules. A quorum is based upon a majority of members. Each house keeps its own journal, and all the committees and proceedings are required to be open and public, but closed sessions are allowed for specified purposes, including employment, safety and security, and litigation. The caucuses of the parties may meet in closed session. The rules related to this section must be adopted by a 2/3 vote, and neither house can recess for more than 10 days without the other house's consent. Section 7.5 of Article 4 provides the total spending for the compensation of members of the legislature cannot exceed a specified amount per member, and each year that amount is adjusted by an amount equal to the percentage increase in the state's appropriations limit. Section 8 provides that only the budget bill may be heard or acted upon sooner than 30 days after its introduction, unless that House dispenses with this rule by a 3/4 vote. Statutes are made by bills. Bills must be read 3 times in each House, although this rule can be dispensed with by a 2/3 vote. Bills cannot be passed unless the amendments have been in print and distributed to legislators. Bills must be passed by a majority vote at least. Statutes generally go into effect on January 1 of the following year after enactment, except special session statutes, which go into effect on the 91st day after adjournment of that special session. A statute goes into effect unless a referendum petition affecting the statute is submitted to the Attorney General. This does not apply to statutes affecting legislative districts, statutes calling elections, statutes providing tax levies, statutes providing appropriations related to the budget, or urgency statutes that go into effect immediately. Urgency statutes are those necessary for the immediate preservation of the public health or safety. Bills with urgency clauses are required to contain a statement of facts constituting the urgency, and urgency statutes cannot create or abolish any office or change salaries, terms, or duties, or grant special privileges or vested rights. Section 8.5 deals with acts amending initiative statutes, the issuance of bonds, and constitutional amendments, but they cannot include or exclude political subdivisions of the state or contain alternative or cumulative provisions. Section 9 requires statutes to embrace one subject, which is expressed in its title. A section of a statute may not be amended unless that statute is reenacted as amended. Section 10 requires each bill passed to be presented to the governor. It becomes a statute if it's signed. The governor may veto a bill by returning the bill with a list of objections. Each House by a 2/3 vote can make the bill become a statute over the governor's objections. If a bill is not returned within the specified time period, then it becomes a statute without the governor's signature. The general rule is that the governor has 12 days to act on a bill, except at the end of session, when in the first year, the odd year, he has 30 days after adjournment, and in the even numbered second year of this session until September 30th. If the deadline is a Saturday, Sunday, or a holiday, then a period is extended another day. Any bill introduced in the first year must be passed out of the House of Origin by January 31st of the second year. No bill may be passed after September 1 in the even numbered year, unless it's a bill to call an election, provide a tax levy, provide an appropriation, or is an urgency statute. No bills may be presented after November 15th in the second year of the session. The governor may reduce or eliminate one or more items of appropriation while approving the rest of a bill. A statement of reasons must be included and submitted to the House of Origin. Items that have been reduced or eliminated must be voted upon separately if the legislature seeks an override. If general fund revenues decline substantially below the estimate for the fiscal year, then the governor may issue a proclamation declaring a fiscal emergency and call the legislature into a special session. If the legislature fails to pass a bill to address the fiscal emergency within 45 days, then no other bill may be acted upon. Section 11 of Article 4 provides that either house may adopt a resolution for select committees or to select their committees. Section 12 requires the governor to submit a budget within the first 10 days of the calendar year, along with an explanatory message and itemized statements for expenditures and estimated state revenues. In addition, the budget bill must be introduced immediately in each house by the respective budget committee chair. The legislature must pass the budget by June 15th. The budget proposal must be accompanied by a budget bill. The legislature cannot send any other bill that appropriates funds until after the budget bill has been enacted, except for certain emergency bills that have been recommended by the governor. Appropriations for the budget bill in public schools may be passed by a majority vote. Budget trailer bills identified as being related to the budget bill may be passed by a majority vote and take effect immediately. The legislature controls submission, approval, and enforcement of budgets and the filing of claims for all state agencies. If the budget is not passed by June 15th, then no salary or reimbursement for legislators may occur until the day that the budget is passed, and any missed pay or expenses are forfeited by the legislature. Section 12.5 of Article 4 provides that within 10 days following the submission of the budget and following the enactment of the budget later in the year, the Director of Finance must submit to the legislature estimates of general fund revenues and expenditures. Section 13 provides that a legislator may not hold any office or employment under the state other than the elected office during his or her term. Section 14 states that a legislator is not subject to civil process during a session of the legislature. Section 15 prohibits a person seeking to influence action by a legislator to do so by bribery, intimidation, or other dishonest means, and violation of this provision is a felony. Section 16 provides that all laws of a general nature have uniform operation, and that a local or special statute is invalid if a general statute can be made applicable. Section 17 of Article 4 states that the legislature has no power to grant or authorize local agencies to provide extra compensation to a public officer or employee after service has been rendered or a contract has been performed. Section 18 grants the sole power of impeachment to the Assembly. Impeachments are tried in the Senate. A person can only be convicted by the Senate by a 2/3 vote. Statewide elected officials, State Board of Equalization members, and state court judges are subject to impeachment, but only for misconduct in office, and they can be removed from office. Section 19 prohibits the legislature from authorizing lotteries. The legislature may regulate horse racing and wagering. Cities and counties may provide bingo games, but only for charitable purposes. The California State Lottery is established. The legislature must prohibit casinos such as those in Nevada and New Jersey in the state. The governor is authorized to negotiate compacts for the operation of slot machines and lottery games, as well as card games by federally recognized Indian tribes on Indian lands in the state of California. The legislature then ratifies the compacts, and the legislature may authorize nonprofits to conduct raffles to support their work if certain specified requirements are met. Section 20 states that the legislature may divide the state into fish and game districts to protect fish and game in the state. It also creates a Fish and Game Commission with 5 gubernatorial appointees appointed for 6-year terms. And these commissioners may be removed by majority vote of both houses of the legislature. Section 21 provides the legislature with the power to fill offices of the legislature and the governor if a certain number are killed or disabled due to a war or an enemy, as well as to convene the legislature and hold elections to fill offices under these types of circumstances. Section 22 requires at the convening of each session, as well as at the close of the 2-year legislative session, for a report from the 4 legislative leaders to be given on their house's goals and the objectives for the upcoming session. Section 28 prohibits any urgency statute that appropriates monies for altering or modifying the historically restored areas of the state capitol or for the purchase of furniture for these areas.